Here, they specifically say in writing that we want to withdraw support from the government. My lord, your lordships, my lord, kindly, my lord, then keep my submissions, my lord. I happen to appear for the governor there, my lord. Kindly, my lord, come to 1369, PDF 1369. Para 42.
page?
1369, my lord. 1369. The governor relied upon, my lord, this. Para 42, my lords have. My Lord Justice Narasimha. The letter sent by the governor to the Chief Minister indicate that the governor relied on the following circumstances in coming to the conclusion that a floor test was urgently required. The receipt of information by the governor that 22 members who had previously supported the incumbent government had submitted their resignations to the Speaker of the Assembly. The members who had tendered their resignations had communicated their decision through the print and electronic media. Copies of the letters of resignation had been submitted by the 22 members to the governor. The 22 members had asked the governor to provide security to facilitate their appearing before the Speaker. Amongst the group of 22 members who had tendered resignations were 6 cabinet ministers whose resignations had been accepted by the Speaker. Now, my lord, may kindly come to 43. It was on the basis of the above material and circumstances that the governor informed the Chief Minister of his having formed the opinion prima facie that the government had been reduced to a minority in the House, making it necessary to conduct a floor test immediately after the address of the governor at the budget session. Then, my lord, para 44, the action of the governor requiring a trust vote be carried out has essentially been assailed on 3 broad grounds of challenge. It has been submitted that governor had no power to order a trust vote in course of an ongoing legislative assembly or at any rate while the legislative assembly was in session. If the governor did possess such a power, then the exercise of the power by the governor in ordering a trust vote impinged upon the authority entrusted to the Speaker under proviso to Article 190, Sub-Article 3B. And 3. The governor had no objective basis or material to form the prima facie opinion that incumbent government had lost its majority in the Madhya Pradesh Legislative Assembly. Now, my lord, questions before the court, my lord, kindly come to PDF 1371, para 46. The present controversy raises 2 separate but intertwined constitutional questions. First, whether the governor is entrusted with the authority to call for a trust vote in the course of a running assembly. And second, whether the governor exercised this authority correctly. If the governor does not possess the authority, the action of calling for an immediate floor test is ultra-vires and unconstitutional. Alternatively, if the governor does possess the authority to call for a floor test, this court must determine the contours of such power and answer the question of whether the governor acted within these contours. It was briefly contended before us that this court should be wary of entering the realm of politics where no judicially manageable your lordships, my lord, can skip that. My lord, kindly come to my lord, page 1372, para 50, constitutional role of the governor. My lord, I don't think, my lord, anything more is required to be said by me, except, my lord, very respectfully adopting my lord's judicial determination. Para 50, your lordships have, my lord. Can I read, my lord? Yes. Para 50. We must consider the constitutional scheme in operation between the state legislature and the office of the governor. As a matter of constitutional principle, the state legislature comprises of the governor and the legislative assembly. The governor is not an elected member of the state legislature. The governor is appointed by the president and is the head of the executive branch in whom, under Article 154, the executive power of the state is vested. While holding office at the pleasure of the president, the governor as a constitutional authority, is not a member of either House of Parliament or the legislature of the state. You know, thereafter, my lords were pleased to trace the history, which, my lord, with my lord's permission, I may skip, my lord, at this stage. My lord, may not be necessary how the governor as a constitutional head came into being. My lord, please come to page 1375, para 757. The Constituent Assembly thus decided to vest the office of the governor with certain discretionary powers under the Constitution. In taking this decision, the Constituent Assembly was aware that there were certain associated risks in granting the governor discretionary powers, including in question of formation, disruption, and dissolution of democratically elected governments. However, the framers felt that this discretion was necessitated by unique historical factors that existed at the time of adopting the Constitution, and it was hoped that with the maturing of our polity, a level of constitutional statesmanship and trust would paper over the cracks of constitutional choices necessitated by more violent times. My Lord, kindly come to, my Lord, para 61 at PDF page 1377. My Lord, all arguments which are made here were advanced, were present before your lordships, and my lords were thereafter, my Lord, pleased to lay down the law. Para 61. The issue of whether a governor can call for a trust vote in an already constituted legislative assembly is not entirely res integra. Before a 9-judge bench of this court in S.R. Bomai, the individual cases which came up for consideration included the dispute emanating from the state of Karnataka. In the state of Karnataka, following elections to the assembly in March 85, the Janata Legislature Party emerged with the majority. Shri Hegde was elected as the leader of the house. My Lord, kindly allow me to read these facts. My Lord, there is something, my Lord, which may assist your lordships. Shri Hegde was elected as the leader of the party and was sworn in as Chief Minister. Following his resignation, Shri Bomai was elected as the leader of the party and was sworn in as Chief Minister on so-and-so. In September, there was a merger of Janata Party with Lok Dal B, resulting in formation of Janata Dal. On so-and-so, a legislator defected from the party and presented a letter to the governor of Karnataka withdrawing his support from the Janata Dal government. The legislator met the governor on the next day and presented 19 letters purportedly of 17 Janata Dal legislators, an independent and a BJP legislator withdrawing support from the Janata Dal government. On so-and-so, the governor sent a report to the president opining that as a result of withdrawal of support, the ruling party had been reduced to the minority in Karnataka Legislative Assembly and recommended that action be initiated under Article 356 of the Constitution. Because if this is the correct assessment of the governor, there are two options, either go for a floor test or 356, which your lordships have frowned upon. Subsequently, on so-and-so, 7 legislators submitted letters to the governor complaining that their signature had been obtained by misrepresentation and reaffirmed their support to Shri Bomai's government. The state cabinet decided to convene an assembly on so-and-so, and the chief minister met the governor, offering to prove his majority on the floor of the house, if necessary, by preponing the assembly session. In spite of this, the governor submitted another report to the president on so-and-so, and a proclamation was issued under Article 356. It was in this background that 9-judge bench, 391, I have already read, my lord. I'll skip that, my lord. Kindly come to, my lord, 65, my lord, para 65 at 1380, where your lordships are now, my lord, analyzing Bomai's judgment in S.R. Bomai case. Your lordships have, my lord. In analyzing the observations made by the 9-judge bench in S.R. Bomai, it is pertinent to remember that the governor in that case did not call for a floor test. Rather, the governor of Karnataka sent a report to the president, based on which a proclamation was issued under Article 356. The observation in Bomai can be relied on in determining whether the governor possesses the power to call for a floor test. So this is what, my lord, I was respectfully urging. I can see both, my lord, but can't help it. Power to discerning the subsequent question of whether, when the exercise of such power is appropriate, is a distant issue. On a perusal of the above observation in S.R. Bomai, it is evident that, your lordship's findings, whether or not the Council of Ministers has lost confidence of the House must be determined only on the floor of the House and not by the governor conducting an independent verification. Where the governor has reasons to believe, he is not supposed to pass a judgment. when he has a reason to believe that incumbent government does not possess the support of the majority in the Legislative Assembly, the correct course of action would be for the governor to call upon the Chief Minister to face the Assembly and to establish the majority of the incumbent government within the shortest possible time. An exception to the invariable rule of testing whether the government has the Assembly's confidence or on the floor of the House is envisaged only in extraordinary situations where, because of existence of all pervasive violence, a free vote is not possible in the House. Then 66. As a matter of constitutional law, it would not be correct to proceed on the basis that constitutional authority entrusted to the governor to require the Council of Ministers to prove their majority on the floor of the House can only be exercised at the very inception after general elections are held, and not when the governor has objective reasons to believe that the incumbent government does not command the confidence of the House. Therefore, I said he should not only command the confidence, but continue to command the confidence. That's, my lord, the requirement of democratic functioning. The governor is not denuded of the power to order a floor test, where on the basis of the material available to the governor, it becomes evident that the issue as to whether the government commands the confidence of the House requires to be assessed on the basis of a floor test. Undoubtedly, the purpose of entrusting such a function to the governor is not to destabilize an existing government. When the satisfaction on the basis of which the governor has ordered a floor test is called in question, the decision of the governor is not immune from judicial review. The court would be justified in scrutinizing whether the governor prima facie had relevant and germane material to order a floor test to be conducted. It must be noted that governor does not decide whether incumbent government commands the confidence of the House. The purpose of holding a floor test in the Legislative Assembly is precisely to enable the elected representatives to determine whether the Council of Ministers commands the confidence of the House. That verification is not conducted by the governor. The decision in S.R. Bomai, in fact, held that recourse to the power under 356 was not warranted in a situation.